Mr. McGee, I mean, I don't even know what happened, but I'm in shock, man. You're on deferred for an unauthorized use of a motor vehicle. Since January, you picked up a failure to ID, an evading arrest, 2 theft cases, another evading arrest, another UUMV, and another burglary of a motor vehicle. So we have.
Whoa, oh, excuse
Hold
me,
on.
sir.
We're going to do probable. I have no idea what happened. We'll do probable cause on all of them because I have no idea. All I know is that you've got 1, 2, 3, 4, 5, 6, 7, 8 open cases.
Okay.
So let's do this. I see. So far, from January 23rd of this year, he had a failure to ID evading. We've already done probable cause. It's been found that there's a bond set. It looks like February 14th, a felony theft was picked up. A bond has been set on that case. Probable cause has been found. Now, as of 2:15, the next day, you picked up a theft, evading arrest, another unauthorized use, and a burglary of a motor vehicle. So we're going to do probable cause on all those cases. You have the right to remain silent. Anything you say can or will be used against you. So I guess, can you start with the theft from 2:15?
Yes.
So in this case, you're facing up to 6 months in jail and or a $2,000 fine.
On February 14th, 2025, officers were dispatched to 6955 Sam Houston Freeway regarding a shoplifter. The call note stated that a black male wearing blue jeans and a brown jacket was inside the store concealing items. The officer observed the defendant walking outside the location and through the parking lot. The officer attempted to make contact with the defendant, who then began to flee on foot. The defendant ran through the parking lot, maneuvering through motor vehicles. The officer was then able to catch up with the defendant and attempted to tackle the defendant to the ground. The defendant was able to slip away and continue to evade. The officer was able to tackle the defendant to the ground, but was still attempting to stand back up and get away. So the officer struck him one more time to gain compliance, and he evaded for approximately 50 yards.
Where was that theft from?
Target, Your Honor.
All right, so I'll find probable cause on both of those cases. So then we have now a burglary of a motor vehicle from 2/19/25. What happened then?
On December 25th, 2024, officers were dispatched for an abandoned stolen vehicle at the Cypress Park and Ride. The officer reviewed surveillance footage taken from December 25th, 2025 and observed the complainant's vehicle. The officer identified a black male wearing a hoodie, blue jeans, and brown boots at the vehicle. The officer immediately recognized and identified the defendant, identified as Zyron McGee, also known as Zion Williams, from a previous case at the same location. The defendant in the video, do so. He then broke the window and got into the vehicle. The complainant did not give the defendant permission to be in the vehicle and was missing a jacket and a charging cord.
Did you say all that was on video too?
Yes, on the surveillance.
The other thing you said it happened December 25th,
5th, yes.
of 25 or 24?
24.
So it seems, okay. So I'll find there's probable cause to go forward there.
Okay.
So what we need to set bonds on these cases. What should we set them at?
Well, of course, defendant is 18 years old, judge, no job. Are you in school?
No, ma'am, I was about to go back to school. They, two of my schools didn't allow me because of my charges of the summertime in 2024, and they denied me school.
What grade are you in?
I'm supposed to be 12th grade. I'm supposed to be graduating this year.
I see one thing. That's what I see.
Yes, sir. But
It's the only thing I see.
yes, sir.
No, no. The problem is, well, you have the right to remain silent. You know, you will have the opportunity to fight these cases. But the problem is, when we let you out, you pick up a case. It's like you're your own worst enemy, dude. Really? Who do you have in your life? Who's there for you? Who do you have?
Yeah, only people I got in my life is my big sister and my brothers and stuff, but we all separated type stuff. I keep trying to keep in touch. I'm trying to keep in contact with them. Other than that, on a day-to-day basis, I have 2 friends that I stay with, and I accompany my friend's father. You feel me? I accompany him on a day-to-day basis. So just, you feel me?
Mr. McGee, you have to make a change before you get killed. You live in Texas, man. People like their guns and they like their cars. And I cannot tell you how many people get shot at and killed because they break into the
Just listen to them.
I'm listening.
After.
I can talk. Yes, sir.
You're trying to think of things to say and you're not listening. You know, I'm trying to give you pointers in life because the problem is you've probably never had someone in your life to tell you, hey man, straighten up and fly right before you land your ass in prison for the next 20 years.
Yes, sir.
Don't thank me. Don't, you know, you think that this is a game and it's not a game, Mr. McGee. You've got 8 open cases now. And the problem is that you cannot use your circumstances to justify the criminality, meaning that I know that you may have had a hard lot in life. We are now here to help you, and I will try to help you in every way that I can. But the problem is that if I let you out, I don't think that you're going to listen to me. I don't think that you're going to do what you're supposed to do. So something's got to give. Either you're going to get a lengthy prison sentence, you're going to grow up in there with probably the wrong people trying to guide you. When you're out there in the free world, if you need help, we can always help you here. All you got to do is ask. But when you're given a bad lot in life, you can still raise up and persevere. It's just how you go about doing it. You understand?
Yes, sir.
You've dug yourself a hole, but it's not so damn deep that you can't get out of. Someday you will, but you have to turn around because something's got to give. You're either going to get a lengthy jail sentence or you're going to end up dead. People like their guns and they like their cars. And when you mess with the wrong person, they're going to shoot your ass dead. And I can show you article after article after article where someone ends up dead because they break into the wrong person's car. I have it here. Once every 2 weeks, someone's dead because of it. I would not let you out unless I know that you have a stable and trusting place to go to. Not a friend, not
Okay.
Mr. McGee. You need time. This isn't something that we just make here on a 2-second whim. I want to give you guys time to talk about circumstance, how things go. Right now, I'm going to set the bonds all at 5,000 and I guess 5,008 because he has 8 cases open. You also have to understand one more thing. You probably don't have anyone in this life that's going to bond you out when you pick up criminal cases. So when you're out there in the free world and you're thinking of things, if I do this, could this land me in custody? Because if it does, you ain't got no one that's going to get you out. That's what you got to think about. You understand?
Yes, sir.
I don't want you to have any contact with any of the people, any of the places, complaining witnesses, no weapons. If you get out, I'm going to give you a leg monitor so I know where you are at all times. I don't know if that's going to happen now, but we need to find something. Something's got to change because what's happening now is just not working. And I'm not going to let you go. Somehow we're going to work this thing out one way or the other. So I guess let's set it a week and then see what you can to find something stable. And then just let me know. If you can, we'll talk and we'll think. The problem is you still have the felony cases upstairs. So even if whatever we do, you still have a $20,000 bond on the felony theft. Is that a stolen car case?
The MJ case was a stolen car. I don't know if the more recent one.
No, there's another 2,500.
Yes, Your Honor. It was out of the same transaction as that most recent one, it looks like. So yes, it was a stolen vehicle.
Can I make it a bond condition that he doesn't go near any cars?
Your Honor, the state would be requesting.
Can't breathe
Yes,
the
they
air.
would.
Yeah, well, obviously, but the problem is I don't know where, to have a curfew, you need a place to go to. So that's one of the issues that we have, right?
I just saw my release or something. I'll verify he has a place to live in a week. Thank you.
It really sucks, man. It really does. I wish that things were different, Start listening to people, people who care, because that's the only way you're going to start getting help around here. Eventually you'll get out. If you ever need anything, we have cell phones, tablets, places for you to go, to eat. You want a job? I can get you a job. We have damn near anything that you could possibly want. All you have to do is ask. Okay. So 5,008 on all the ones that don't have bonds now.
So the ones that do have bonds, 25 ones.
Yeah, just leave it at, just leave it as.
The attorney generated her own.
Guys, hey, I don't want you to talk here because we got a whole audience here. It's not good. Just, we'll get you back there talking.
Thank you, Judge.
We'll work it one way or the other, but you're your own worst enemy, my friend.
Yes, sir.
It's got to stop.
I will.
Okay.
Thank you, Judge.
Thank you. Yes, ma'am.
Before we move on, audience, put yourself in the judge's seat for a second. Would you have handled this the same way or gone easier on the defendant?
Good morning, Miss Moss. Ma'am, you were charged with theft. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On February 13th, officers responded to a theft call at the Carters located at 1257 West Bay Area Boulevard. Dispatch advised that one female, the co-defendant, was concealing items in a bag and underneath her sweatshirt, while the other female, the defendant, was handing items. Claiming witness stated that the females were walking out of the store past all points of sale. Officers located both females walking out of the store located on the sidewalk next to the store, traveling west on foot. The co-defendant attempted to ditch the clothes where she threw them on the ground. Both females were detained. The co-defendant was identified as a juvenile. The complaining witness provided video footage of the theft, and the total of the merchandise stolen was $186.
Okay. Do you have the co-defendant? Do we have it? That person here? Do you know? Do you have a cause number?
It's a juvenile, Judge.
Juvenile.
I believe that they would be in.
Okay. All right, Ms. Moss, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go to any Carters. Do you understand? You were on bond for another case and now you've picked up a new case. Really, at some point, we're going to just revoke the bonds and make them high. If you're a danger to the public, there's only one place that we have. Do you understand, Ms. Moss? Did you want to apply for a court-appointed lawyer, ma'am? Okay. Do you mind filing no going to any Carters, please? And who is the co-defendant? Like, do you have a relation? Because I'm going to order no contact with that person.
Let's see, Judge, if I can find it.
Whatever.
I just have the identifying information, the initials IM. I believe she's 15 years old.
Is there, or did they list a relation of some sort? Do you know?
I don't see it on the Denver, Your Honor. We don't have the evidence report back yet.
I guess we'll wait and let me see. So for now, ma'am, I'm going to have you sign a receipt with Victoria. I need you to fill in an application for me, and then we'll have you take a seat in the jury box. Do not leave until you sign our bond conditions. Do you understand? Okay, please. Deputy Manager, would you?
Quick question for you watching. If this were your family member in court today, would you want the judge to be stricter or more compassionate?
Mr. Frazier, you're charged with burglary of a motor vehicle. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officers were dispatched to burglary of a motor vehicle. CW, the complaining witness Hargrove and complaining witness Vargas stated that their backpacks were stolen from their work truck. They stated that their vehicle was unlocked. A witness was able to provide ring camera footage showing a suspect walking across the street to the vehicle. A few minutes afterwards, it was found that complaining witness Hargrove's phone was used to send $400 via Cash App from the complaining witness Hargrove's to the defendant. Officers were able to use this transaction to get a picture of the defendant through the Cash App. The complaining witness Hargroves sent this photo to a cousin and said that a friend knew the defendant from high school. Officers looked on social media sites and matched the pictures to the Cash App account.
Okay. Mr. Frazier, so you also had a theft case. I didn't realize. So you're charged with theft. You're also charged with burglary of a motor vehicle. I'm going to find that there's probable cause to go forward on both of your cases. When was this? Was this in the middle of the night?
Sorry, George, 2:23.
So 2:20 in the afternoon. Okay. Mr. Frazier, I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail. Do you understand? I'm going to do everything in my power to protect every single person of Harris County. And if that means making you bond really high and putting you in custody, I'm going to do it in a heartbeat. Do you understand? Yes or no?
Yes.
How old are you, sir?
Right. I work at a nursing home. I work at a nursing home.
So you do work.
Yes.
Do you want to apply for an appointed lawyer, sir? Okay, Deputy Miranda is going to give you an application for an appointed lawyer. I'm going to have you supervised. You're not to be in possession of any weapons as well. Do you understand? I'm telling you, behave yourself while you're out there in the free world, because if you don't, the free world will be taken from you. Mr. Frazier, I think that you make too much money to have a court-appointed lawyer. Do you not, where do you live at home with mom or dad, or who do you live with? Yeah, I mean, you make a lot of money and you have literally no expenses, so I can't really give you one. So what we'll do is we'll give you time to hire a lawyer, and then we'll have you sign a reset. There's a gajillion and one lawyers out there. It's getting on the phone, interviewing one, finding one that you like. 99% of lawyers will put you on a payment plan as you go. So you just a couple $100 here, there, however, like anything in life, you get what you pay for though, right? They're the Mercedes-Benz of lawyers, and then you got the Yugo of lawyers. So just be careful, all right? Don't be a danger to my city, man. You know what I mean? Really. All right, come on. Oh, he already? So I guess we need him to sign conditions.
Right, so they'll just.
Okay, yeah, just take seat. We'll have two conditions.
Think about this carefully. In your opinion, should the court focus more on punishment or on actually helping people change?
Then you're gone.
Yes, sir. How you doing this morning? I apologize for being late.
It's okay. I'm
Yes,
glad
sir.
you made it.
I'm just glad I was able to call and let you know because I was gonna come, no matter if I had to
You're
start
here now.
walking.
That's what matters.
Yes, sir. Amen.
Tell me your last name again.
Gary, Gary. My name,
Stop. Don't, please. You have the right to remain silent. Exercise that right. I have a bunch of DAs here, and whatever you say, that they can try to use it against you. So that we'll talk here momentarily, and then I'll let you get out. But I just don't want you to say something that hurts you, So, Ms. Gary, you're charged with assault of a family member. You are facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
On February 16th, 2025, within Harris County, Texas, officers were dispatched to a disturbance. The officers made contact with the defendant, who stated that she and the complainant were in a dating relationship. The defendant stated that she and the complainant were in a verbal argument when she stated that she did not like his comments. And the defendant stated that she assaulted him by punching, biting, and scratching him. The complainant stated that there was a physical altercation and that his injuries were in fact from the defendant. The officer observed several scratches, bite marks, and bruises on the complainant's body.
What is the relationship? Do you know?
They were in a dating relationship since October 1st, 2024.
Okay, so Ms. Gary, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond. Well, what I'm going to do is I'm granting a protective order. This is a protective order that identifies Mr. Ovanian as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand? This is a very serious court order that if you violate, the state can and probably will file a violation of a protective order against you. It's one of the worst cases you can pick up. So just don't. Now, would you like me to provide you with a lawyer? Okay, I will give you a lawyer today. Everything that you wanted to tell me, tell it to the lawyer, and then they can, if need be, come and talk to me and we can try to resolve any issues that may come. I'm afraid of what you would say to me. If they're going to hear it, it's probably not a good thing, Do you have any other questions?
I can go to jail for a year.
That's the potential punishment in this type of case. It's up to a year in jail and or a $4,000 fine. That is an assault. And this type of assault.
Yes, sir.
So, but that doesn't mean it's going to happen, It just, the potential, that's all.
Yes, sir.
So I need you to fill out an application for me though. So Deputy Echegoyen is going to give me an application. I just need you to fill it out. Do not leave until you sign our bond conditions, and then I'll have you talk to a lawyer here.
So am I still, do I have to pay anything on the PR bond?
No,
Okay, thank
not paying
you.
anything.
Thank you. Oh, well, they said I had a $90 court fee.
Don't listen to them.
God bless you, sir.
Good morning, Mr. Guzman. Sir, you're charged with criminal trespass. You're facing up to a year in jail because of the deadly weapon paragraph. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 2nd, 2025, at approximately 5:30 p.m., officer was dispatched to 1201 Spencer Highway in Harris County, Texas, for criminal trespass. Upon arrival, officers made contact with the complaining witness, who stated that the defendant attempted to stab him with a knife in the parking lot. Officers attempted to make contact with the defendant, and the defendant began running north through a strip center and tried to hide behind the strip center. Officers told the defendant to get on the ground, and he continued to walk toward officers and refused to take his hands out of his pocket. The defendant was arrested. Officers retraced the defendant's path and located a knife. The defendant admitted to having the knife and stated several males tried to jump him in the parking lot. The defendant stated one male tried to stab him and he was defending himself. Officers spoke to the complaining witness again. They said that he was in the store purchasing items, and the defendant was asked to leave by the employees in the store. The complaining witness stated that the defendant refused to leave and got into a verbal altercation with the employees. The defendant left, then waited outside in the parking lot and started asking to differ money. The complaining witness told the defendant that employees had asked him to leave. The defendant pulled out a knife and brandished it in his hand and started walking towards the complaining witness. The complaining witness stated that there was about 25 feet between them. The witness saw the defendant walk towards the complaining witness.
So he goes back into the store after he leaves and after they told him to leave.
Yes.
Okay. Mr. Guzman, I'm going to find that there's probable cause to go forward with your case. Let me tell you that you're lucky that you're not charged with multiple felonies as well as it is, you know? I am ordering you not to be in possession of weapons and not to go back to this place. Do you understand?
Sure.
If I find that you become a danger to my community, I only have one place for you, Mr. Guzman. You know, really. I already have an affidavit and Deputy ran it. All right, so what I'm going to do is I'm going to have you go sign a receipt with Victoria. We'll have you take a seat in the jury box. I'm going to find you a lawyer here momentarily. Do not leave until you sign our bond conditions.
Sir.
You have missed court once. This is your second PR bond that they gave you. You will not get another one. If you miss court again, I'm telling you, your bond will, no more PR bonds. Do you understand?
Thank you for,
Giving you a lawyer. All you need to do is stay out of trouble. Make wise decisions.
sir, could I say,
No,
I just want to
no.
thank you for,
Just,
I called last week when I was supposed to come. I had a car problem. I didn't even think, thank you for giving me the second chance on the PR bond. You know, and I mean, it was, I called, but I understand.
you're out. All I'm asking you to do is make good decisions.
Yes, sir. Yes, sir. Yes, sir. I understand, sir.
Give you a lawyer here momentarily. Just, all right. All right. Hang tight. Let me have you sign the reset and then we'll have you go back.
Honest question. Do you feel safer because of decisions like this? Or do you think they might actually make things worse?
All right.
All right, then next is case 6.
So no weapons, no going back.
Come on up.
Good morning, Mr. Murdoch. Sir, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 16th, officers observed a blue Kia Forte at 6300 Antoine Drive. The officers observed the vehicle make a U-turn where there's a prohibited U-turn sign. A traffic stop was initiated. Officers had previously observed this vehicle pulling out of a known after hours bar located at 6314 Antoine Drive, Harris County, Texas. The defendant was a driver. Officers observed short speed, bloodshot eyes, and a strong odor of alcoholic beverage. The defendant admitted to drinking 2 Bud Lights. Standard field sobriety tests were performed, 6 out of 6 HGN, 1 out of 4 one-leg stand, and 4 out of 8 walking turn. The officer observed a 12-ounce Bud Light bottle of beer that was open and about 3/4 full upon an inmate.
Drinking in the car while driving.
There were also 2 unopened shooters of tequila and meal console. The defendant consented to breath. TAC came back as 0.112 and 0.109.
I missed the basis for the stop. Can you tell me that one more time?
They saw the vehicle perform a U-turn in an area where the U-turn was prohibited.
Okay. Mr. Murdoch, I'm going to find that there's probable cause to go forward with your case. I would figure that it was damn elementary that you're not to have alcohol in the car while you're driving. I am now taking away your privilege to drive. You were not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. And I don't give a rat's behind what your excuse is if there's a burning building and you have to save 50 children. Do you understand? Every time you drive, it's punishable by up to 6 months in jail and a $500 fine every time you drive. Mr. Murdoch, I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you if I find that you're using. Likewise, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer, sir? I'll have you fill out an application. I'll see whether you qualify. Heed this warning, Mr. Murdoch. You will not get another one. Do not become a danger to my city. All right?
Get this way.
Mr. Vieira, you are charged with driving while intoxicated, second offense. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 24th of 2023, officers observed a dark sedan stopped at the light traveling westbound on Washington Street. And when the light turned green, the officer began to go, and the motor vehicle, a black BMW, almost struck a patrol vehicle on Shepherd Drive, causing the officer to hit the brakes. The motor vehicle then proceeded to drive southbound in North Shepherd, driving down a one-way street. A traffic stop was conducted. The officers approached the vehicle and observed a mild odor of alcoholic beverage coming from the vehicle and an open liquor bottle on the floorboard behind the passenger seat. The defendant was identified as Christopher Vieira. The defendant was observed to have bloodshot eyes and slurred speech. The defendant stated that he had not been drinking and he was just driving around. As officers were conducting the walking turns, the defendant stated he had surgery on his foot/leg when he was a baby and that something was wrong with him. HGN, 6 out of 6 clues, walk and turn, 5 out of 8 clues, and a one-leg stand, 2 out of 4 clues. During an inventory search, the officers found that open Escalon tequila bottle. The DIC was red and the defendant consented. The breath results were 0.133 and 0.1.
We've had a lot of issues with Mr. Vieira. And this case is now 700 days old. Take a seat for me in the jury box. Let's wait for his lawyer to get here. Good morning, Ms. Wells. Ma'am, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On February 15th, officers were dispatched by the Harris County Transit Authority dispatch to a reckless driver in the 5200 block of South End Houston Tollway. Officers observed the vehicle failed to maintain a single lane and nearly strike 3 different vehicles. A traffic stop was initiated. Officer observed slurred speech and disheveled clothing. The defendant admitted to drinking. SFST were performed 6 out of 6 each again with vertical nystagmus. Officer was not able to conduct the walking turn in the one-leg stand due to being unable to maintain her balance. The defendant consented to breath. Came back as a 0.296 and 0.297.
Any prior DWIs? Ms. Wells, I'm going to find that there's probable cause to go forward with the case. Can you run your license as well, please? I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you consume anything, I'm going to revoke your bond and put you in jail. Do you understand?
Yes, sir.
If you have a problem with drugs or alcohol, now is the time to address it, because if it becomes an issue, I'm going to do it for you. And I promise you're not going to like the way that I do it. Do you understand?
Mm-hmm.
Okay, you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you don't have car insurance, you may not drive. Do you understand?
Mm-hmm.
Okay. Tell me, do you have the ability to hire a lawyer? I'll have you fill out an application. I'll see whether you qualify for an appointed lawyer. If you do, then we'll appoint you someone. For now, I'm going to have you meet with Victoria. We'll have you sign a reset. You'll eventually get with Fleischer your bond conditions, and then Deputy Miranda will give you an application.
Here's something to reflect on. If you were the defendant here, would you feel treated fairly or targeted.
Are you Miss Andre?
Yes.
Miss Andre, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On February 16th, officers were dispatched to a disturbance in Harris County, Texas. Officer made contact with the complaining witness who stated that he and the defendant had been in a 2-year dating relationship. Complaining witness stated that he broke up with the defendant and was trying to kick her out of the apartment. And the complaining witness was trying to force her out. The defendant punched him several times in the body, bit him, and broke a wine bottle on his head. The officer observed an open wound on the complainant's head and bite marks.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. There's a protective order that has been issued in this case. I would get to know it. If you do something to violate that protective order, the state can and will file a violation of protective order against you. Now's not the time to fight your case. I mean, if you need a lawyer, we can help you with that. Otherwise, you can go hire a lawyer and speak to them and they can help you fight the case. Do you have the ability to hire a lawyer or would you like a court-appointed lawyer, ma'am? I'll have you fill out an application. I'll take a look at it. Hold on.
I'm sorry, I thought.
I'm issuing bond conditions on you now. You're not to have any contact. You're not to have any contact with this person. And I don't want you to have any weapons. If I find that you're a danger to my public, I'm going to revoke your bond and put you in jail. Do you understand? Okay, Deputy Mayor, do you mind giving us? Okay, I'll have you sign a reset and then we'll have you take a seat in the jury box. How's jail? Sucks?
It's not for me.
It's not supposed to. Good. That's what I want to hear. You know? Do you speak Spanish?
Sir.
My mom used to tell me, dime con quién andas, yo te digo quién eres. Tell me who you hang out with, and I'll tell you who you are. That's what life is. When you hang out with dogs, you're going to end up with fleas. I don't know if that's what's happening now, but I told you I don't want you smoking, and it's continued to happen. Now, what should we do? Should we let him out? What do you think, Mom?
I agree with the same curfew. I want the same curfew he has. Everything just maybe drug test randomly.
What do you think?
Yeah, I'd like to see him out. Number one, Judge. I mean, his mom, he's got asthma. I think he's learned he needs to be out of there. I think he understands using the friends as an excuse is not going to fly. Being around people that smoke weed, that ain't going to get you positive. I explained that to him. You know, based on the videos, which I watched, he needs to understand who you're hanging out with is the reason you're getting in trouble. Like Judge said. Okay?
You know, you have but one life. The more cases you start catching, the harder life gets. It doesn't get easier. The older you get bigger, fatter, uglier, you lose hair. Life doesn't get easier. And if you don't have a trade, if you don't have an education, you're going to end up in and out like all those other mofos in there now. Look at all the old timers in there. They're children who never grew up, never did anything with themselves, never amounted to anything. So all they do, they end up doing dope, they end up stealing that's not a life, man. You got a mom that cares.
You understand you're here because you got in a car of someone else driving that decided not to stop, right? You understand who you're hanging out with is getting you in trouble. They've now landed you in jail 2 times. You understand that, right?
Yes, sir.
The day you got arrested and now when Judge put you back in. And you can blame your friends for the second time Judge revoking your bond. But you need to understand you are putting yourself in this position by choosing to be around these people. So it's your decision how this goes. Okay?
Yes, sir.
I'm here to help you and get you out of this. But you got to help yourself. You got it?
Yes, sir.
Okay.
No hanging around with these people. It is a condition of your bond.
Sir.
I will give you another chance, but I will not play this game with you again. You continue to smoke. You continue to hang out with the people that you're hanging out with, or you pick up a new case. I'm going to put you in, and I will not let you out again. You will be stuck like Chuck until this case is over with. And I tell you, it takes 9 months just to get a damn 911 tape. I'm all over the state repeatedly because of it. Do you understand?
Yes, sir.
This is the last chance you have with me. Okay? I'll reinstate the bond today. Same conditions fly. We test him in 40 days again, 40 to 45 days. If you're dirty again, get ready. You understand?
I'll also give you random drug tests too from the agency I work with, so just to keep up with.
But he's gonna test with us. I want to know because I know.
No, definitely.
Right. Okay. All right, man. Make me proud. That's all I'm asking you to do.
Sir.
So what is he doing now? Is he in school or
Yes.
full time, right?
Yes.
Okay. All right. Keep it up.
And I'm gonna get a mitigation packet in here.
Done.
Okay.
All right. You're out today.
So much.
It's the last chance.
Yes, sir.
Okay, man.
Thank you.
You got it.
Reset when you,
Whatever you want.
okay, normal.
Let me ask you this. Do you think strict conditions truly prevent crime or just push people deeper into trouble?
You were on bond for a theft, and now you've picked up another theft and an evading arrest. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On February 13th, officers were dispatched to a theft call at Lowe's. The officer spoke to the complaining witness, who's the loss prevention officer. The loss prevention officer stated that the defendant entered the store and put a speaker into his backpack. The loss prevention officer followed the defendant around the store. The defendant walked out of the store, passing all points of sale.
Hold on.
To purchase the item.
Oh, you didn't?
Yes.
I was going to give him a coloring book. Okay, go ahead. So he's in Lowe's?
Yes.
All right.
The complaining witness attempted to stop the defendant. The defendant did not stop. The officer was on scene when the complaining witness was attempting to stop the defendant. The officer told the defendant to stop running and the defendant did not comply. The defendant ran approximately half a mile from the Lowe's. The officer caught up with the defendant on the third floor of an apartment complex. The defendant attempted to resist detainment. The value of the item stolen was $129. And the defendant started to run from the complaining witness towards the nearby apartment.
Mr. Castillo, I'm going to find that there's probable cause to go forward on your theft and your evading arrest. Deputy Miranda, I'm now revoking your bond on your first case. You will now go into custody. I told you not to pick up any new cases. You picked up 2 new cases. You will now stay with me. Goes with you.
I'm sorry about that, sir.
You appoint him a lawyer, please. I will appoint you a lawyer now and we'll talk, but no, you can't continue. Unacceptable. Are you Jackson Norton?
Sir.
Mr. Norton, you were charged with 2 counts of assault bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
February 15th, officers responded to 1025 West Mass Parkway, Bar Buckwild in Harris County, Texas, regarding a disturbance. The first complainant stated that he was located at the bar ordering drinks and was in a conversation with the defendant. After the complainant turned around and the defendant struck him on the right side of his face. The second complainant stated that he observed that the defendant was leaning over the first complainant, physically hitting the first complainant. In an attempt to break it out, the second complainant grabbed the defendant and the defendant turned around and punched him on the side of the head. The second complainant stated that he believed he was unconscious for multiple seconds. When he woke up, he was laying on the ground. The defendant left the establishment where his bouncers were able to locate and detain the defendant in the parking lot. A witness, the bartender, observed these still on the second complainant. The second complainant had injuries to the left side of his face where it was pink, and there appeared to be broken blood vessels under the skin, with small laceration near the end of his eyebrow, where there was a small amount of blood. The first complainant advised he felt pain and had a small little bump on the end of his elbow next to his eyebrow next to his hair.
So we have 2 assaults that were dismissed early last year. Any of the complaining witnesses the same?
No touch.
Same set of facts, whereas alcohol as well?
The previous assault happened at a high school graduation party.
But there was alcohol?
Yes, Judge, it's not the assault.
Mr. Norton, I'm now going to find that there's probable cause to go forward with your case. I'm now putting an ankle monitor on you so I know that you're not consuming alcohol. If I find that you do, I will put you in jail and I'm going to make your bond high. Do you understand?
Yes, sir.
We're now working on our 4th, so I will do everything in my power to protect my public at all costs. Do not use alcohol, do not use illegal drugs, no weapons, no going to any bars, clubs, establishments where it's 50% or more alcohol, no going out in the middle of the night. You will get a curfew as well.
GPS. Whisper.
Sure.
Nine to 6.
Sure, yeah.
Judge, I leave earlier in the morning for work.
I'll give you a lawyer. I'll have the lawyer talk with you, work out any kind of detail, but my concern and my only concern is the protection of my city, and I'm going to do it at all costs.
Yes, sir.
Do you understand?
Yes, sir.
Nothing else matters to me in this life right now. If I find that you're a danger, I only have one place for you.
Yes, sir.
Waive all the fees, please. Mr. Norton, I'll have you fill out an application for an appointed lawyer and I'll see whether you qualify. I'll have you go to Victoria, sign a reset. Deputy Miranda's going to give you an application. I'll have you take your seat in the jury box. Do not leave until you sign all the conditions. And then I'll take a look at the application, sir.
Yes, sir.
Jackson Norton, you just gave him bond conditions, and I wanted to know if we can amend the curfew because of his work.
Okay, I knew that he had issues. What would you like?
Judge, he'd just like to remove the curfew, but keep the restriction from any bars or alcohol, or places that serve alcohol, so that he doesn't go around there. But his
So
job
what I said is he cannot go to any establishment where it's 50% or more, where there's like a true bar. If he's going to like a Longhorn Steakhouse, if he's going to, you know, Papacitos, that's okay. But if you're going to a bar like the Marquee, or you're going to, that's unacceptable. No bars, nightclubs, you know, anything of this nature, because I don't want him to, I mean, we're working on our fourth assault now. No, you know, and so I don't want him out in the middle of the night. I'm willing to work with you on the curfew, but
So from what he's told me, he works 8-hour shifts, but he's also he's maintenance, so he can be on call and have to leave at 4 o'clock in the morning to get to work if there's an emergency. So he just wants to make sure that he won't be violating bond conditions if he has to go to work. My documentation that he.
right, I need proof because I'm not going to take his word for it. So bring me proof and then we can talk. But yeah, I mean, I'm not going to take his word for it that he gets up at 3 in the morning or 2 in the morning to go to this place and that place, and you know. So, but show me something like that, and then yeah, we can work.
Okay, so
But-
we'll keep the curfew in place, and then if he needs to travel forward, we can provide proof that he's clocking in and clocking
Right.
out.
No contact with any of the complaining witnesses, no weapons, and then he's got the device on his ankle, so we know he's not consuming too.
You did a scram? Okay. So scram and GPS is what you're doing?
No, I didn't. Yeah, I guess so that we know that he's not out in the middle of the night, you know, and if you know, after some time, if he's good, then we can amend the conditions as far as the GPS.
Okay.
Scram.
30 to 60 days?
I mean, be proactive, you know what I mean? Show me, I want to know that there are not going to be any more issues, but yeah, okay. Thank you.
7 to 7?
No. I don't know. He said he had a problem with 6. I didn't know. What did I do? I didn't do 7 to 7.
Sorry, we're gonna do 9 to, the standard 9 to 6. 9 PM to 6 AM? I think he has to be at work at 6 AM, right?
So, yesterday,
Can you
I
come
still
up
do 5 a.m.
9 PM to 5 AM? Okay.
so just yesterday, I was from 6 to 11 at night.
Yeah, I'll give that 5 in the morning,
Thank you.
but don't want any more issues.
Like, early, can I do like, midnight? Because sometimes it's 30 minutes drive back home and I get off at
I'm
11.
giving you till midnight. It's not going to happen. And I want proof of anything that, as far as work is, like, I'm not going to take your word for it. So I need proof that, you know, that they're actually working at this time, and then we can work on your schedule, but I'm not letting you out in the middle of the night. It's not going to happen.
Sure.
Okay. Thanks.
Judge, 9 to 5, Judge. 9 P to 5 AM.
9 to 5, right. Yeah.
So we're gonna amend.
So, Mr. Ibarra, you were charged with driving while intoxicated, second offense.
Yes, sir.
You have worked out an agreement. They're offering you 30 days in jail, credit for the 2 days that you've done. You need to understand something very important, that you are making a lifetime decision today, and a very serious one, because anytime you get pulled over from now on, an officer is going to look you up and they're going to see DWI, yada. What do you think they're going to do if they come up to you and they smell alcohol?
I'm straight to jail. Bring me to jail again.
Right. This time, though, you're looking at 2 to 10 in the penitentiary, because then a third DWI, it's a third-degree felony. You're looking at a whole boatload of time in custody, up to 10 years in prison, and all you need to do is just have the faintest smell. Do you understand?
Yes, sir.
If I were you, even if you had a sip of alcohol, I wouldn't get into a car, because it's a huge risk. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law, you give up the right to appeal. So once you plead guilty to this, it will go on your record. It'll stay there for the rest of your life.
Understood.
This is what you want to do.
Yes, sir.
How do you plead to the offense, sir? I will find you guilty, sentence you to 30 days in jail. I will give you credit for the 2 days that you've done. I am going to suspend your license for 1 year. What do you do for a living, sir?
Work out at an refinery. Aviation.
Okay. The reason I'm asking you is because there is a surcharge that you're going to be required to pay. We will give you time to pay it, but this is a second offense, so you're going to be required to pay it. It's a $6,000 surcharge that tacks onto you. And if you don't pay it, every $100 you owe, you will sit 1 day in jail. Do you understand?
Yes, sir.
I'll waive the court cost.
Yes,
He's
Your
going
Honor.
to be required to pay that fee.
Yes, Your Honor. And Your Honor, I did have one request that I wanted to put forth before the court. Due to his job, he is a foreman at his job. I wanted to see if possible if the court would consider allowing him to do his jail time on weekends.
No, like
He said he can literally do every weekend until it's satisfied.
we're not allowed to do that.
I explained to him the court's general rule.
All right. You're going to have to do it flat. It'll be easier now. If you want to go in later today, by 6 p.m. we can do that. If you want to go in now, you can go do that now, but it's got to be a continuous
Yes, sir.
stretch. What do you want to do? You want to go in now or do you want to go in later today? Right now?
Yes, sir.
Okay. All right. So Deputy Miranda, do you mind remanding him into custody so he can serve his time?
Give that 10 minutes. Thank you, Your Honor. I'll be excused. Have a good weekend. I told him the court's policy, Your Honor, but he
Yeah.
still wanted me to ask.
The problem is that it costs way too much in man time.
Yes,
We don't
sir.
even do sweep anymore, which is like a work release program. They don't do any of that anymore since COVID. It's
Okay.
all,
All right. Thank you, Your Honor. Have a great weekend.
let me see. Okay, guys. Yeah. Take care. Yeah. Come on up. Hi, James. Come on up.
Audience, based on what you've seen so far, is this justice being served or power being exercised?
Sorry about that. I was in court 7 all
Don't worry
morning.
about it. I'm happy to have you,
Mr. Vera is in bond forfeiture for a long time, or? Let me see, Judge.
So you're still on it.
Yes, Judge.
I'd like you, please, because
Sure.
what I'm going to do now is, I'm putting an ankle monitor on him.
Okay.
Come up. Come up.
You mean a GPS monitor or a SCRAM device?
Oh,
Oh, okay. One for each ankle. Okay.
you get a curfew of 7 to 7. And then is discovery complete? Please tell me it is.
Yes, it's complete, Your Honor.
You have 2 weeks to figure out what you want to do on this case. You must be back here in 2 weeks and I will either set your case for trial or you will accept a plea bargain agreement. But you have multiple bond forfeitures. You have had bond violation after bond violation after bond violation. Today, you get 2 monitors. One is a scram, so I know that you're not consuming alcohol. The other one is GPS monitor, so I can keep tabs on you. And let me express in the event that you ever take off on me, I will do la cucaracha on the bond. Do you understand? Do you have an offer on this case, please?
Yes, there was a 30-day and an 18-month probation.
You're not to consume alcohol, illegal drugs. You will be randomly tested. Does he have a Texas driver license, please?
I'm gonna run it right now to see if it's eligible.
There is already from 2023 an order for you not to drive. You are not to drive. I don't care what's going on in your life. If I find that you're driving a car, I will have a contempt hearing. Do you understand?
His license is suspended.
Okay. You don't have a Texas driver license. You are not allowed to drive. One ankle, you understand you'll get a scram monitor, your other ankle a GPS monitor, and I'm giving you a curfew of 7 to 7. Back here in 2 weeks, you must accept the plea bargain agreement. It is your responsibility to get with Mr. Sims. If you do not get with him, then if you have immigration issues, it's your responsibility between now and then to also see an immigration lawyer as well. Do you understand?
Yes, sir.
Okay.
Thank you,
All right,
Judge.
I'll see you in 2 weeks. You will get with Fleischer for your bond conditions.
That's good. Just, do you want to have a seat in the jury box?
Come right now.
Okay.
Mr. Carollos.
Yes, sir.
Sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay,
Just
please.
remind me of the last name, please.
Carollos with a K.
Hey, I Thank you.
Is it?
On or about February 15th, officers paced a vehicle going 80 miles per hour in a 65 mile per hour zone. A traffic stop was initiated. The defendant was the driver of the vehicle. The officers observed slurred speech and odor of an alcoholic beverage, and the defendant appeared disoriented. The defendant stated that he had drank an IPA juice a few hours before at a friend's house. The standard field sobriety tests were conducted. 6 out of 6 HGN, 2 out of 8 walk and turn, and 0 out of 4 on the one leg stand. The DIC was read and consented to. The defendant blew a .139 and a .131.
Okay, any priority to the eyes?
No, Judge.
Okay, Mr. Carollo, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If you test positive for drugs or alcohol, if you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, Your Honor.
You have a lawyer because you have one. I will waive your appearance, so you don't have to waste your time coming to court, but stay in touch with him and he'll tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, likewise, I'll issue a warrant for your arrest. Do you understand?
Yes, Your Honor.
I'll have you sign a receipt of Victoria. We'll have you get with Fleischer for bond conditions, then you guys are free to go.
Judge, one thing I wanted to address, I've already spoken with pretrial services. My client has a work trip scheduled for this Sunday through this Thursday out of state. I would ask, apparently it's not going to be a frequent thing that he's traveling out of state. Would you consider waiving the drug testing until Friday of next week when he
Well,
comes?
I mean, from the time of the trip to then, okay, but you're not allowed to use. I'm going to test you as soon as you get back. If you test positive, it's really not going to go well for you.
Yes, Your Honor.
Okay? Okay,
Thank you.
absolutely. Happy Friday.
Happy Friday. Buenos días, señor.
Buenos días.
Parece aquí, por favor, conteste a voz alta.
Okay. You are Mr. Pavez Vargas.
Sí.
Yes.
Sir, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine.
$2,000.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 15th,
El 15 de febrero.
officers
Los
observed
oficiales observaron
that Nissan SUV failed to maintain a
que no
single lane
mantenía una vía
5 times
5 veces
and observed it
y
to slow down
observaron que
and
bajó la
rapidly
velocidad
accelerate
y rápidamente aceleraba
several times
varias veces
before initiating a
antes de
traffic stop.
iniciar el acto.
The officer observed the
De los
defendant to be
oficiales observaron que
and
el
delayed in
acusado
responding
se
to
tardaba
his
en
questions
responder a las preguntas
and struggled to locate his
y
driver's
luchaba para localizar su licencia de manejar.
The defendant advised he was coming from a wedding
Dijo que venía de una boda
and he had one
y que
beer.
había tomado una cerveza.
Standard field
Le
sobriety
dieron
tests
las
were performed,
pruebas de campo,
4 out of 6
4 de un 6,
HDN,
HDN,
4 out of 8
4 de
walk
un
and
8,
turn,
caminar y golpear,
3 out of
y
4
3
one
de
leg stand.
4 para una pierna.
The defendant consented to breath
El acusado dio permiso para dar su aliento
and he blew a
y sopló
.08.
.08.
You said that he 5 times
5 veces
failed to maintain a single lane of traffic.
una vía de carril.
And you said that he slowed down
Su
and then
velocidad.
he sped up.
Yes, Judge.
What else?
¿Qué más?
Because as far as the 5, that's just completely conclusory. So I take nothing with it, right? I mean, everybody slows down, goes back fast. So
Bajan su
what
velocidad.
else do you have as far as any kind of traffic infraction
Entonces,
other than that?
That's what I'm reading in
Eso es lo que leo.
this, Judge. Let me see if there's
En
any
esto,
more
señor.
information in the office.
Su señoría, deje ver si hay algo más en la defensa. Me reporte.
It does say that after the
que
emergency equipment was turned on,
se
the
prendió
suspect failed
el
to
equipo
pull
de
over for
emergencia.
approximately 2 minutes.
Él no se paró por aproximadamente 2 minutos.
I don't know if he articulated more maybe in an OR, but there's just not much there. I mean, Blaze, I can give you a little bit of time if you want to try to pull the OR, maybe like 10, 15 minutes.
Y más para que miren a ver lo que hay. Otros 10 o 15 minutos. Y que no se mantuvo en una vía nunca.
Okay. All right, Mr. Pavez Vargas, I'm going to find that there's no probable cause to go forward in your case. Sir, we have enough death and destruction on our streets as it is. Be mindful of this. If you want to have 15 beers, 32 shots of tequila, take an Uber. Save yourself the trouble. Do you understand?
Yes, see.
Okay, all right, thank you. Please.
Next is page 13, Rodriguez, come on up.
Tell us what contact with your person.
With either of the complaining witnesses, right, going to like bars, clubs. You, Luis Gilberto Rodriguez. Mr. Rodriguez, you were charged with reckless driving. You were facing up to 30 days in jail and or a $500 fine. We're going to be probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officers were assigned to after crimes unit in Harrisburg, Texas, on an operation targeting illegal street fixing and parking lot takeovers in an undercover capacity. Officer at 11737 East Tex Freeway in Harris County, Texas, observed the driver of a 2007 flatbed Ram with one multiple donuts in the parking lot. The vehicle was maneuvered in tight circular motions, causing the rear tires to lose traction and produce visible smoke at all stations. The Ram headed towards the exit of the parking lot when the vehicle executed a burnout, causing its tires to emit smoke and a loud screeching noise. As the driver of the Ram initiated a turn to proceed east on East Mount Houston Road, while the vehicle fishtailed. During the maneuver, the Ram flew close to striking several vehicles and must have been multiple accidents. The officers conducted a traffic stop on the vehicle.
Got it. Can you look to see any priors of this same or similar nature? Please?
Yes, Judge, I'm not showing any criminal history.
No? Okay. Mr. Rodriguez, or one more thing, if you can look for a license, please,
Yes.
valid license. Mr. Rodriguez, I'm going to find that there's probable cause to go forward with the case. Let me just give you a little warning that the Texas legislature has made it very easy for DAs across the state of Texas to seize and take cars for people who participate in this type of activity. In fact, I think that there was a news conference maybe 2 days ago where they're cracking down on this type of behavior. And I've seen it where here we have people who've had their cars seized and taken when they're multiple times in this. Do you understand? I'm ordering you as a condition of your bond not to participate in any street takeovers, donuts, reckless driving, anything of this nature. If I find that you do, I will revoke your bond and put you in jail. And then I will take your driving privileges away. Do you understand? So do you mind filing that? No reckless driving, donuts, et cetera. All right, Mr. Rodriguez, how old are you, sir? 18. Do you have the ability to hire a lawyer? Or would you like to apply for a court-appointed lawyer? Okay. Deputy Miranda, Deputy Miranda is going to give you an application. I'll have you sign a receipt of Victoria while you take a seat in the jury box. Do not leave until you sign our bond conditions. You understand? Okay.
As we head toward the final stretch, after everything you've watched, do you trust the system more or less?
This is the one where we were, you remember? It was like maybe 2 days ago? The two Bs?
Yes. Yeah. Yes. I do.
Good morning, Ms. Harrison. Hey, good morning. Ma'am, you're charged with tampering with the government record. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On February 15th, officers observed a vehicle with temporary tag. The officers ran a temporary tag and returned to court. Defendant Martin was the driver and defendant Harrison was the passenger. Defendant Harrison stated that she was the owner of the vehicle and that she had purchased the tag from an unknown individual off Facebook.
Okay. Ms. Harrison, I'm going to find that there's probable cause to go forward with your case. Can you run her license to see if she has a valid Texas driver license, please?
Yes.
Okay. Ms. Harrison, did you want to apply for an appointed lawyer? Do you have the ability to hire a lawyer?
Apply for one.
Okay. Deputy Miranda is going to give you an application. Do not drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand? These are your bond conditions. If I find that you're driving without either, I will revoke your bond, put you in jail. Understand, man?
Yes, sir.
Okay, please.
All right, Judge, next is page 7, Huddleston.
Good morning, Mr. Huddleston. Sir, you're charged with tampering with a government record. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On February 16th, officers observed a vehicle with a temporary tag, which came back with no return. A traffic stop was conducted. The defendant was the driver and sole occupant. The defendant stated he knew about the tag and had been pulled over the week prior. The defendant stated his mom went to the dealership and bought a new buyer's tag for the car. The defendant did not know how much the new tag would cost for.
So why does Mr. Huddleston get charged then? Oh, it's pled differently. It's pled differently. That's why. See. It's pled here as use as opposed to purchasing, and I think that's why. So let me see.
And I did notice it showed up as tampering with the record insurance document, but it looks like on the complaint, it is tampering with the record.
Hereinafter, style the defendant heretofore February 16th did then and there unlawfully, intentionally, and knowingly use a governmental record, namely Texas temporary tag, attached hereto as Exhibit A, with knowledge of its falsity. So one of the parts is it says with knowledge of its falsity.
Yes, Judge.
Does he know of its falsity?
Well, upon the officer approaching the vehicle,
Okay.
he knew immediately what the traffic stop was for. That he'd been pulled over the week prior because of it.
He had been
Yes.
and advised that it was no good. Just read it one more time.
Officers temporary tag, which came back with no return. A traffic stop was conducted. The defendant was the driver and sole occupant. The defendant stated he knew about the tag and
Okay. Okay. All right. Mr. Huddleston, I'm going to find that there's probable cause to go forward with your case. Can you run his license, see if he has a valid Texas license, please? I am ordering you as a condition of your bond, sir, not to drive any vehicle unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Yes, sir.
These are your bond conditions, meaning that if you don't, all of these bond conditions, a warrant for your arrest will be issued. You will go to jail. No more PR bonds. What's more is you are on felony probation. You've not picked up a new case. Best be on the lookout. It's very possible that they now issue a warrant on you.
His license is valid. Judge.
Okay, so you mind filing that then? No driving with that, both, please. Tell me, Mr. Huddleston, do you have the ability to hire a lawyer? I'll have you fill out an application. I'll take a look to see whether you qualify. All right. Do not leave until you sign our bond conditions. You understand? Okay, come on. Mr. Wilson, you were charged with theft. You were facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On August 18th, 2023, complainant witness saw the defendant enter the store, which was a Dick's Sporting Goods, and try on a pair of sunglasses and then request to try on a pair of shoes. The defendant tried on the shoes and placed them back to the box and continued to browse. He then selected a pair of socks and then put the socks and the shoes on and exited the aisle and made no attempt to take the merchandise to his sale. So the value of the goods was $185. Officers reviewed the video and confirmed that there was no attempt made to pick the goods. The complaining witness was able to recognize the defendant from one of his prior booking photos using a photo.
What does that mean, prior booking photos from?
Are you asking for what it's charged with?
I'm guessing he has a prior theft at the same place.
He does have a prior theft charge. Let me look up. store.
Does he have any open cases right now?
No judge does this fact. The previous fact was from a different store.
Mr. Wilson, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now not to go to any Dick's Sporting Goods at all, anywhere. Do you understand? I'm going to protect everyone in my city and everything. If I find that you become a danger, I only have one place for you. Do you understand? That's not an answer. So better. You have this air of arrogance to you, Mr. Wilson, but you're now here. Really? Do you have the ability to hire a lawyer? Okay, we're going to reset your case to give you time to hire a lawyer. I'm going to have you sign a reset with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go, sir. Mr. Shaw, you're charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On February 12th, officers observed the defendant's motor vehicle bearing a paper Texas tag. And an NCIC, TCIC search of the tag came back with no result, so a traffic stop was initiated. Officers made contact with the defendant. Defendant said he purchased the motor vehicle approximately 2 months ago for $2,000 from a mutual acquaintance, but did not have title to the vehicle and did not have insurance for proof of financial responsibility, and that he purchased the tag from a separate mutual acquaintance for $80. The defendant stated that the paper tag was not affixed to the rear of the motor vehicle he purchased, and that he purchased the tag separately until he could have the motor vehicle registered.
Mr. Shaw, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Yes.
You will be signing an affidavit with me today, which is a promise that you're going to make to me that you're not going to drive without either. If you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
Bond forfeiture citation on both sides.
Okay. Mr. Shaw, do you have the ability to hire a lawyer? I'll take a look at an application. I need you to fill it out for me. I need to know everything about you, what kind of car you drive, how much money you have in the bank, how much money you make. I'll take a look to see whether you qualify.
Yes, sir.
For now, I'm going to have you also sign this affidavit that you're not to drive without insurance as well.
Approaching on the Matthew Gomez case, and Judge, he's here and it's on your bond docket, but there's a BVR issue. I've talked with the state about it. Talk to them about what I think are some interesting issues, kind of by way of background in our case. And the state had previously offered, though we had not yet gotten a contract, to do a 90-day mental health PTI, which we felt was appropriate. They're going to review with the felony court to determine whether they still believe that may be appropriate, but they can't do that at the moment. They're going to have to get some feedback and find out a little bit more information about the new felony charge. I read the cases and think there's issues with both of the cases. But there is the pending BVR based on having picked up the new felony charge and need to.
Is he here?
Yes, he's here.
Come up.
Yeah, call him up.
Please.
And it's not really an issue to delve into, but I think there's issues with the way the police officers maybe made the stop in the new case. And
if he's picked up a felony offense, I'm very upset.
We understand. And
let me express my disappointment with you, Mr. Gomez. You picked up a felony assault of a peace officer while you're on bond for this case. What happened, please?
So in the felony, the officer dispatched to a suspicious person call at a closed gas station. They observed the defendant walking around the vacant lot holding 2 glass bottles of Corona beer, indicating possible intoxication. They attempted to stop and identify the defendant, but he ignored commands and walked away towards the main road. And despite multiple warnings, he refused to comply, and he threw a glass bottle at an officer before fleeing on foot. Officers pursued the defendant for half a mile before detaining him, and while being transferred between patrol units, the defendant had already moved his hand restraints to the front of his body, and the officer attempted to reposition the restraints behind him. That's when the defendant pulled away and struck the officer's left thumb with his elbow, causing pain, redness, and tenderness. And then the defendant attempted to flee again, but was taken to the ground.
And I think there's issues with walking up and saying, we see someone and no more. Well,
it's not our case to litigate.
Well,
all I know is that you've now picked up a felony case. Where'd you going? I got to take him.
Well, Judge, if we're going to be revoking him on that, then I do think it is our issue to delve into And I think there's issues with the way he stopped. And, but if that's going to be the basis to revoke him, then this court doesn't. But the entirety of the information that the officers receive is based on what I would contend is an illegal stop. You can't just walk up and say, without more, there's no
Go
reason.
up to a guy and say, hey, let's talk.
No, that's not what they said. They said, walked up and said, show me your ID. And that's an illegal detention. That is a detention, and it's one that's unlawful under the circumstances.
I don't know.
Well, I'd like to set it for a hearing if we're going to do that. Sure. And he posted bond, 10,000 in the felony case. We think that's sufficient to ensure that he appears for a hearing, a formal hearing on it, without needing to take him into custody. I've talked with his mother. His mother has had good contact with me throughout this process, and she'll ensure that he's here. I think if we set it for early next week, then we can delve more into the felony case and figure out if the mental health, and I think the state can get an answer about whether mental health treatment is what's appropriate. We think it's appropriate, and even if you delve into the background of our case, the allegation is that he called the police himself and said, hey, I've got traffic tickets, come arrest me, come to my home and arrest me. The allegation, well, and that he also said, and when you get here, I'd like to be in a fight. And when the cops arrive, they oblige him, they put their tasers away and fight him. And that's consensual conduct. And whether we like it or not, humans have the ability to consent in physical fights if they like in Texas. And it may not be something that we would do or agree with, but legally people are entitled to do that. And so he's not resisting arrest even in our case. So we think there's issues in our case, but we thought on the defense side that it may be more appropriate to go the Harris Center route and see if mental health PTI.
I appreciate your argument. I appreciate your tenacity, but I have to be fair to every single person that comes through here. We have certain standards and procedures that we follow.
Sure.
When anyone picks up a felony case, especially a violent felony case, we revoke the bond and we put them in custody. We cannot continue to act in this manner. We are a civilized society and actions have consequences. I'm happy to give you a hearing, but no, I'm taking you into custody. You picked up a felony assault of a peace officer.
Judge, and my position respectfully is if he's entitled to, Judge, maybe before he be taken away, we finish this portion of the hearing. I think he's entitled to be president. But we think it also a part of due process that before a revocation occur, that you're entitled to both notice and an opportunity to be heard. And if they're going to be seeking to revoke his bond, then under our rules of evidence, it's very clear in Rules of Evidence 101 that a revocation, the rules of evidence apply. And everything that's gone on this morning is a proffer by the state, and I respect the proffer, but that doesn't meet the standard for the rules of evidence. And that's why
the judge found that there was enough probable cause for a felony office to be filed against him.
Sure.
I don't want to relitigate a felony case here in misdemeanor court.
And I think that's fine. Well, but I think we're entitled to if we're going to be, and that's what the hearing would be for. But that
one of the conditions of his bond is not to pick up any new cases. He's picked up a new case.
And as an evidentiary matter, there's been no presentation that he violated the conditions of bond. I know that you can look in your system and even take judicial notice of that court's finding, but that finding and pleadings that charging him with a new crime, those are not self-proving. And if they're not self-proving, then there's no actual evidence that's been presented. And we'd be entitled to ask questions to prove up, for instance, that they illegally stopped him. There's no basis for that detention. And so respectfully, I'd like to say—
I'm not going to relitigate the felony case. I'm not going to. You know, I respect your position, but I'm not going to.
Well,
he violated a condition of his bond.
Says who?
Says a felony court magistrate that put on the case again. That
entitled to heard it on that.
And he did in felony courts.
I don't believe that's—
he goes in front of a magistrate. He has a defense lawyer in the magistrate, you know, when they do the magistration. So he does.
Well, I think he's entitled to be heard here. If you're going to revoke his bond, I think he's entitled to be heard here. And that hasn't happened. And certainly hasn't happened in accordance with the rules of evidence.
I would just say that, just reiterate that a district court has found probable cause in this case. They said there's no evidence that he violated a condition of bond. It's flat out wrong because a district court judge has found probable cause on this bond. She is picked up.
And that's not self-proving. Otherwise, in trial, they could just come in and bring in that piece of paper that finds probable cause and submit that as evidence, and they can't. That's not evidence. Those are not self-proving findings.
We're not in a trial here, right?
Well,
you know,
no, I know it's
this is just, we're having a bond hearing.
Sure.
He's violated the condition of his bond. I understand that you don't like it. I appreciate your tenacity, but he okay, and reasonable minds can differ, but he's picked up a felony case and there's a certain process that we follow.
Well, and so we'd like a hearing on that.
Yes, I will give you a hearing. Yes, but I'm taking him into custody because he's revoked it and he's a danger to the community. I find by clear and convincing evidence, he refuses to comply with his conditions of bond. Goes with you. I'm sorry, Brian, but I mean, really,
Well,
every case, when they come in here and they pick up a new case,
I respect.
just especially a felony assault of a peace officer,
I understand.
you know?
I just believe that it puts the cart before the horse to make the decision to revoke based on pleadings when case law is abundantly clear that pleadings themselves are not self-proving and that the rules of evidence apply in a revocation proceeding. It's in Rule of Evidence 101, I believe. And nothing that has taken place this morning has been in accordance with the rules of evidence. I understand the courts. I understand that as a historical matter, folks come in and proffer information and I proffer information and we don't do it from an evidentiary standpoint. And that may be what the hearing would serve to accomplish. And so if the court's position is after a hearing, you'll revisit the issue about whether to reach a final decision to revoke his bond or not, then we can respect that.
Sure, I'm happy to do it.
Okay. And in the meantime, I guess I do need to request that the bond, a new bond be set in an amount that he can.
Of course. Yes.
In the event that his family elects to get him out before the hearing. And in light of our discussion.
What I normally do in these types of cases, I always set it at 5,001. Okay. If you reach out to the family and they have a problem, then we can talk about it.
Well, now, let the court know the bond was set at 40,000 in the felony case and reduced to 10,000 because the family doesn't have a bunch of resources. His mother is at work to get him out on bond on that case and is going to have to do the same here, but it's really money that's coming out of the mother's pocket. And so which my whole position was get him access to resources. Now we're diminishing resources. And I respect that. I understand, but it's the mother's resources, not his. And so, and the mother, and we knew this issue was coming up this morning and he showed up. And that's part of the goal is to ensure that he appears, and he did, and to ensure the safety of the community. And I think that part of the finding will address the hearing. But I've been.
What do you want as far as the bond?
Well, I'd like it to be at 2,500. And
say, okay. When I have this kind of issue, I always split the puppy. So I'll set it at 3,750. Okay. If there's still an issue, come back and we can talk.
Yes.
But there has to be a sufficient so that he understands, right?
Well, and part of the discussion was, do you really get to that point of understanding if, for instance, the allegation, even underlying our case, is you call the police and say, come arrest me, I've got warrants, supposedly telling on yourself. But when you get here, I'd like to engage in a fight. And then they come and oblige him. I don't know that that's even resisting arrest. And so,
well, it seems like to me that he's just trying to take off the whole time. He's trying to physically, or he's evading the entire time.
No, I think it's
when
case
he
two.
throws something at
That's
the
the felony
officers.
charge. I'm talking about our underlying.
Oh, our case. Okay, I'm sorry.
And I think probable cause had been heard before I even got appointed on that case. But I think even revisiting those facts, I've talked with the state at length over the course of settings. And my position is, if you invite someone to a fight and they say, sure, we'll engage in a fight.
If you want to set this for a formal probable cause hearing on the resisting, I'm happy to do
Well,
it.
we may address it at the same time we do the bond hearing on the same case, if
Happy to
that's
do it.
appropriate.
Absolutely. I'm always willing to revisit probable cause,
Yeah,
always,
I know.
at any time, whenever. So just if you want to set it for 3 days, we can have a formal probable cause hearing on the resisting. I'm happy to do it.
It may give the state a chance to find out what felony's position would overall
And
be.
that's, that's safe, but I don't want to litigate a felony. I wouldn't think that's proper. I understand they're entitled to a hearing, but the district court judge is not probable cause on this. I'm not going to be in a position to litigate the felony now.
Right. Let's set it for 3 days, set it for the hearing. Let's do probable cause as well on the resisting, and then we'll come back and be ready. And then if you can show me that there's no probable cause, I'll find no probable cause, then we're done. That's it.
I appreciate it as always, Jim.
Absolutely.
Thank you. Thank you.
As these hearings unfold, notice how every small decision connects to a much bigger picture. The judge isn't just reacting, he's weighing behavior, risk, and responsibility in real time. What can look like strictness is often an attempt to balance fairness with public safety, making sure the courtroom protects both the individual and the community.
Mr. LaDon, you were on bond for a terroristic threat. You've now picked up a criminal mischief. You were facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 11th, 2025, the officer responded to a physical disturbance at a residence in Harris County, Texas. Dispatch advised that the caller was reporting he had a knife and was going to stab someone because they were bothering him about a broken window. The officer made contact with the defendant and the complainant, and the defendant stated he called the officer. The defendant was found to be in possession of a green stuffed animal which had a fixed blade kitchen knife concealed inside. The defendant stated the complainant came to his house with her roommate, accusing him of breaking a window at her apartment.
Well, hold, you're going really fast.
Yes, Judge.
The defendant,
Called the officer.
okay,
And he said that the complainant had come to his house with her roommate, accusing him of breaking a window at her apartment. The defendant stated he was walking back to his apartment and that the complainant came out the back door to her apartment, but then he changed his story saying that she came out the front door to her apartment to confront him. The defendant stated that the complainant came with a gun, though he did not see the gun. The complainant stated that she was laying in bed, heard a glass window in the back door break, jumped up, ran to the back door, and saw the defendant walking away from the door, holding a green stuffed animal with a knife. Apartment management stated the cost to repair the window was $200.
There's a lot of randomness in it, Judge.
the only thing, my concern is who broke the window? Did he break the window?
Thank you, Your Honor. So according to the DMs, what the complainant says is that she saw him walking away. She heard the broken window. She came downstairs and saw him walking away. And then that's what we have in the DMs. And then I spoke with her yesterday as well. She repeated the same thing, that he was the only one there when the window was broken. And that's what she said. She saw him outside the window door when it was broken.
He's walking away. He actually calls the police because he's being harassed by this woman because she's saying that he broke a window. And I don't think there's any list of physical evidence like glass on him or anything, or in the whatever stuffed animal.
At what point did the cops come and did they arrest him on the spot? What, do we have any other physical evidence? Do they?
We have the two brothers of complaints said that he was approximately 20 feet away from the back door when she saw him, and that the officer found the window to be shattered. And then the complainant showed the back door to her apartment.
I mean, how do we know he did it?
No one's saying that he did.
I mean, no one saw, you know? It's,
To be honest, just what we have is that the window was broken, and then she saw him outside at the time when she came downstairs to check on it. That's what we have.
I get it. I get it. I don't think it's enough. However, the fact is, we're still having issues with the same complaining witness. I now have to take more drastic action to ensure nothing happens in the future. So now what I'm going to do is I'm putting an ankle monitor on it and I'm barring him from going within 500 feet of where she lives or where she works.
Yes, Judge. Ankle monitor, just want to make sure it's ELM and not scram.
Correct.
Okay. Acid fees be waived. Okay. I'll add.
How far do they live from each other, Alex? You know?
Do you think that's complex?
It was described as across the street. But when I spoke to the complainant, she said that they do not live across the street, that he was staying at a friend's house, but he told the officer that she lives across the street.
So what I'm doing, Mr. Franklin, is I'm going to put a monitor on your ankle and there is a radius of where you cannot go where this person lives or works. And I mean, we may have issues with bond conditions as it is, because if I ordered them not to have weapons on the terroristic threat and they show me that, or they prove to me that you have weapons, I'm going to put your butt in jail. So maybe we should have a formal bond hearing to see if, in fact, you can prove that he has a weapon.
So I have some hesitancy about everything, Judge, mostly because my client's orange sheet is quite extensive. So the jail has diagnosed multiple mental illnesses. I'm trying to track down his competency because I was appointed, I think, December. So there's been prior competency motions. I'm trying to get the reports from them, which is difficult because I forget what agency does the mental health evaluations. They're saying that they don't exist. So I'm trying to find his mental health records, Judge. It sounds to me like it's bipolar schizophrenia or schizoaffective. And so I think that my client is likely going to have severe mental health issues, which have been causing issues. And I think that's going to be the heart of all this. And so I'm trying to push for treatment. The case is just brand new is the problem.
You ordered not to be in possession of any weapons. And they're telling me now that you have a new case and that you have an alleged knife as well. I want to set this for a formal hearing on Monday. And if they show me that you have a weapon in violation of your bond conditions, I'm going to bring it. Do you understand? You are not to be in possession of any weapons whatsoever. Get a hold of your witnesses, get a hold of the cop. Let's have a formal hearing on Monday to show me whether he's in possession of a weapon or not.
Yes, Judge.
Yes, Judge.
In the meantime, like I said, if I find that you become a danger to my community, it's really not going to go well for you. Do you understand, Mr. Franklin? There is no excuse. You will get this ankle monitor today, and you're not to go within 500 feet of where this complaining witness lives or works.
If I can politely ask, Judge, that we reset for more than Monday, only because this case is new enough that there's literally no offense report, so I don't know officers' names or.
Case.
So the new case, the criminal mischief, which will be the allegation for the motion to.
Find no probable cause in the criminal mischief.
Well, but the problem is, Your Honor, is that it's on the criminal mischief that we have the officer that saw the alleged knife. So we'd have to get in contact. We don't have the OR. We have the name. I could reach out, but we don't have the OR to give defense. So they can review it. And
So the allegation is, and it's, we don't have an OR, so we're reading DIMS. So the allegation sounds like the officer saw a knife, or maybe the CW saw a knife. It's unclear.
To me, it sounded like both saw a knife. So that's why. So, I mean, I guess I'll give you a full week. You know, that should be sufficient for you to get an OR, get in contact with both witnesses.
just to clarify for both parties here, the officer is the one that said that when he contacted him, he found the defendant in possession of the knife.
Okay, let's have a hearing.
Yes, Judge.
Get this guy over here. If you need to subpoena him, do it. So that in today's Wednesday, we'll have a hearing next Wednesday.
Thank you, Judge.
All right.
This is where courtroom decision-making becomes truly complex. Every answer, every hesitation, and every past violation shapes what happens next. It's not simply about punishment. It's about risk, trust, and accountability. Judges walk a fine line between giving people a chance and keeping the public safe.
Good morning.
Hey.
How are you?
Hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay?
Be right back there. She's gonna read it again,
Okay. What happened?
On January 10th, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle and the defendant due to him pulling away. The officer began to roll around on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
No.
Just losing?
So, Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location being told to leave, and they observed him verbally refuse, and then...
Right, but then cops get up there.
And then they observed him begin to walk away, and it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and...
Didn't say that.
That was in the complete dims, Your Honor. And then...
You know about that?
And
Yes, Judge,
behavior.
but I have my argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement
I smell marijuana. You look intoxicated, because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, we identified ourselves as police. So what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey, I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called, yes, a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So the trespass investigation ceases because he's leaving. Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is?
Okay.
The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Yes. Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
He's
leaving, right? It's like, here, let me come and mess with you more.
That would only,
right? So it's like adding fuel to a fire.
They would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw him refusing to leave, and he only
leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't undercut their ability to investigate what they observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm going to find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we?
Yeah.
You don't like to wear orange, do you? Be careful where you go. Be careful what you do.
Yes, sir.
Everyone's always out to get you, man. Don't let them. All right, man. Good luck.
Thank you.
Unless you.
You were Mr. Jefferson. Mr. Jefferson, you're charged with 2 cases. You're charged with harassment. You're also charged with terroristic threat of a family or household member. On the terroristic threat, you're facing up to a year in jail and or a $4,000 fine. On the harassment, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Which one, Your Honor?
Are they one and the same?
They're not out of the same transaction, Your Honor.
Okay. I guess start on the harassment, which is the earlier one.
Yes, Judge. On October 15th, 2024, the officer met with the complainant at her residence in Harris County, Texas, regarding a terroristic threat call. The complainant advised the defendant is her ex-boyfriend, who she was living with until April 2024, when she decided to move out. The complainant stated she received a photo of the defendant with a firearm to his head, and after the complainant blocked the defendant, she started receiving multiple emails from him asking for half the rent. When the complainant refused, the defendant sent her a message via email saying, "If I lose this place, I have nothing to lose after that, so I'll be sure to put you there, and that I promise." The complainant went to work, and she advised the defendant was at her job and refused to leave despite her request and stayed outside in his motor vehicle. And then, would you like to hear that?
So the harassment is the text, I'm assuming?
The harassment is the multiple emails, including the message via email saying that the threat.
Okay. All right, go for the terroristic threat. Same complaining witness?
Check, Your Honor. Yes, Judge.
Okay.
So for the terroristic threat on January 2nd, 2025, the officer was dispatched to the residence in Harris County, Texas, in reference to a terroristic threat call. The officer met with the complainant, who stated the defendant messaged her stating she paid her portion of the light bill and the complainant needed to come and pay the other portion. The defendant messaged her twice on TikTok, saying the same thing. And the complainant stated via TikTok, if the bill was not paid by the 4th, there will be problems. The complainant received additional messages from a TikTok account with the username account not found, meaning the account was deleted or disabled. And the account stated, I try to be respectful. I promise you, if it is not paid, I will put your social security number and personal information on the internet and I will shoot up that house, starting with your bedroom. The complainant stated she is in fear for her life.
Is there any kind of immediacy to this thing? Do the covers back. The stairs. Stairs.
Your Honor, he specified that prior that if it's not paid by the 4th, there will be problems. And then he's again repeating that state, if it's not paid, that he will shoot up the house. The threat would be, I will shoot up the house.
There's no contingency in a terroristic threat. It's a threat. Here, you have an act that's contingent on something else, right? That's not, no. All right, so Mr. Jefferson, I'm going to find there's no probable cause on terroristic threat. However, I am going to find that there's probable cause to go forward on harassment. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand?
Yes.
You are also not to be in possession of weapons. If I find that you become a danger to our community, I have one place for you. I will revoke your bond, put you in jail, no more PR bonds. You missed court yesterday. We issued a warrant. I will reinstate your bond today, but this is the only get out of jail free card you get. You miss court again, I will revoke your bond, no more. Do you understand?
Sorry.
It is your responsibility to know when to come to court and when to show up. We have given you a lawyer. It is also your responsibility to stay in touch with the lawyer. If he tells me he can't get a hold of you because you're ducking and dodging, likewise, I have one place for you. Do you understand?
Sorry.
So can you file no contact, no weapons, please?
Yes, Judge.
On the harassment?
Yes, Judge.
So what we're going to do now is I'm going to have you sign a reset with Victoria. We'll have you take your seat in the jury box. Do not leave until you sign our bond conditions, then we'll wait for your lawyer to show up.
Judge, just approaching again on Mr. Jefferson. The state is asking for his next appearance to be required so they can serve him with a civil protective order out of the 280th. I would ask for his appearance to
How's
be.
that going to work?
Yeah, so, Your Honor, in this case, the complainant through our office is applying for a protective order. So we're just asking for his appearance to be required so we can serve him the protective order, and then the civil division will take it from there.
I would object just for inconveniencing him, Judge. And don't they usually just have a deputy come out to your house and serve you?
I don't know. I mean, I've never done the 280th domestic violence to where I don't know. I mean,
I've encountered them a few times, but I've never dealt with the process of my clients being served them. They just get served.
So you apply, you've got the hearing, you have to serve him so that way he can go to the hearing in the event that he wants to
And that's
contest.
all we want to do is get the process started so we can protect our complainant case. And we would have had him served today, Judge. I just don't believe that things have been,
Want me to do a protective order now?
No, this is the long-term civil protective order, not just the MOAB, Your Honor.
And they already have a no contact.
We do, I believe, have a MOAB on file.
You want me to put a MOAB in now?
Sorry?
You want me to put, did I already do a MOAB?
Yeah, I thought you did.
I believe we do have a MOAB in this, well,
No.
in the prior case we do, in the new case,
No, that wasn't signed.
Let me,
We just-
in one for
yeah,
now,
yes.
because I know that he has the harassment, he has the other terroristic threat. I didn't realize that you guys had filed it.
Judge, he doesn't live with the complainant. They share no children together. He has no problem staying away from her.
Mr. Jefferson, come up. Mr. Jefferson, on your harassment case, I'm entering in what's called a magistrate's order for emergency protection that identifies Ms. Green as a protected individual. As of this day forth, she's now protected, meaning that you cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this court order in any way, the state can and probably will file a violation of a protective order against you. It's one of the worst cases you can pick up. Do you understand?
Yes, sir.
So I'm going to have you sign this now. The state's asking me to have you come back so you can be served, but I don't do that in any case. And I don't want to show preferential treatment for you guys, you know, like I would show preferential treatment to them, because unless I know that the person is a flight risk or homeless to where we know we're not going to get a hold of them, I normally waive on everybody. And I can't, it wouldn't be fair for me to show preferential treatment to have them,
Your Honor, we
you know?
just had to ask.
So will acquiesce in granting a protective order now, but So what I'm going to do is I'm waiving your appearance so that you don't have to come back and waste your time in court here. But you must stay in touch with Mr. Sims. And if he tells me he can't get a hold of you, then I'm going to issue a warrant for your arrest. No more PR bonds. Do you understand?
Yes, sir.
So if you start to become a problem out there in the free world, I will take the free world away from you. No more PR bonds. You pick up a new case, no more PR bonds. You start harassing, no more PR bonds. I'm not asking for much. All I want you to do is stay away. There are a gajillion and one fish out there in the sea. It's not worth throwing your life away. You understand what I mean? Life is way too short to live in a 6x9 box. Jail sucks. It's not fun. All right. I'll have you sign the protective order and then we'll get you guys out of here.
Thank you, Judge. Thanks.
By the end of today's docket, one thing stands out. Choices have real consequences. Every warning, condition, and ruling reflected a balance between fairness and responsibility. Judge Fleischer consistently measured risk, behavior, and public safety before deciding. In this courtroom, justice isn't about being soft or harsh. It's about being consistent and accountable.